A will with witnesses. This is what I will be explaining in the following video. According to the inheritance law of 1965, there are basically four types of wills. There is a will in front of an authority, which can also be a notary or a court. There is a will that's a verbal will, and there is a will that's handwritten, and then there is a will before witnesses. And this is the will that we will discuss now. There are basically two wills that require witnesses. The one is the will before witnesses, and the other one is the verbal will. Both these wills basically require that two witnesses be present when the will is given. And when it comes to the will before witnesses, the ideal situation, according to section 20 of the inheritance law, is that both witnesses are present at the time the testator is giving his last will and testimony. This will needs to be written. It can be handwritten, or it can also be typed. But the most important thing is that the witnesses confirm in their testimony that the testator understood the content of the will and signed the will in front of them. Those are basically the essential points that witnesses are confirming. In addition, on the technical level, it's very important that the will has, of course, signatures, and has a signature also of the testator and also of the witnesses, and that it includes the date when the will was created. It's important to understand that, essentially speaking, the inheritance law is supposed to fulfill the desire of the testator. And many times you might also have technical problems. In situations of technical problems, basically, according to section 25 of the inheritance law, the judge can rectify any technical problems in order to still fulfill the desire of the testator. When it comes to the witnesses in this specific will, a will before witnesses, both of the witnesses need to be adults according to section 24 of the inheritance law, and they need to be basically with legal status, meaning someone that can legally make decisions for him or herself. In addition, according to section 35 to the inheritance law, the witnesses will basically be canceled if they are themselves enjoying and benefiting from the will. Like if they're actual heirs or spouses of heirs, then the whole will basically is canceled. We always recommend, and this is a recommendation we give for all the wills, especially today in the modern era when everyone has smartphones, which was not the situation in 1965 when this law was passed, to also take a video of the will, no matter what will it is, whether it's a verbal will, a will with witnesses, a will in front of an authority or a notary, or even a handwritten will. To basically take a video. If it's a handwritten will, you can also just take a selfie of yourself giving the will. But this, of course, will have a very strong bearing when you want to implement the will. And if there are any technical mistakes, it will help the judge to basically understand the testator and his desire when he actually sees a video of him reading out the will, or basically just proclaiming his desires and last will and testimony. I hope that this video was productive and helpful. If you have any further questions, you can feel free to contact us, and we'll be happy to be of assistance.